Is filing a provisional patent application really worth it? Welcome to the Patent Bootcamp, the 4-part series that'll teach you everything you should know before getting a patent. By the end of this video, you'll understand what a provisional patent application is, how to avoid common mistakes, and when it's worth it to file one. Let's get into it. The United States follows a first-to-file system when it comes to patent applications. That means the first person to file a patent application gets the rights to the invention, even if someone else came up with the idea first, but just didn't file. It's a race to the patent office. The day you file your patent application is critical to securing your priority. This is where the provisional patent application comes in. A provisional is a way for you to secure your filing date without needing to file the full non-provisional patent application right away. Essentially, a provisional is a placeholder. It's not examined by the patent office, and it doesn't result in a patent. But here's the beauty of it. The provisional gives you 12 months to file a non-provisional patent application and to keep that earlier filing date. Think of it like a trial run. During that 12-month window, you can refine your invention, test the market, and even raise investment money without worrying about someone else beating you to the patent office. You can also say your invention is patent pending during that 12-month window. Patent pending status can serve as a deterrent to potential infringers, and you can use it as a marketing tool to show investors that your invention is on the way to full patent protection. Your provisional patent application will never become published, unless you file a corresponding non-provisional patent application. And even then, the provisional will only become public once the non-provisional becomes published. Another benefit of provisionals is that they're cheaper than non-provisionals. The filing fees at the patent office for a provisional patent application are between $65 and $325, depending on the size of your entity. They're a great way to dip your toes into the patent process without the heavy upfront costs. If you want a full summary of the financial costs and financial benefit of patent protection, watch this video, linked in the description below. Can I file a provisional patent application myself, or do I need to pay a patent attorney to do it for me? Great question, other me. As a general rule, it's a bad idea to write a patent application yourself, even a provisional. But it's better than nothing if you don't yet have the funds to hire a patent attorney. The reason it's so important to do the job right in the provisional application is that only the content you describe in the provisional will get that early filing date. In other words, if you add new content in a non-provisional application, that new content won't get the benefit of the provisional's earlier priority date. When you file a non-provisional patent application, the patent office can be pretty particular in determining whether the content in the body of your patent application is close enough to the content in the claims to meet the written description requirement. That means that in a lot of cases, a poorly written provisional application won't have everything it needs to adequately describe the claims of your future non-provisional. One way to address this issue is to always include claims in your provisional application. They're not formally required, but by including claims in the provisional, you can use them as a checklist to make sure that everything in the claims is described in the provisional application. I like to make sure that every element in the claims has a corresponding element in at least one figure, and a near verbatim description in the body of the application. Again, it's not required, but it can save you a lot of heartache down the road. The next step I recommend is watching the other 3 videos in the Patent Bootcamp series, linked in the description below. And if you want my help getting a patent, please go to INRIpatentlaw.com/contact. My name's Brad Hankelman with INRI Patent Law. I'm a licensed patent attorney with experience representing everything from Fortune 500 corporations to brand new startups. If this video is helpful to you, don't forget to subscribe and to hit the bell icon so that you're notified when we post new videos.